Again, the materials that I have shared on this cover even more topics than I'm going to cover just in light of time. But I want to share some common kinds of things that concern carriers and missteps that we just see over and over and over and over again. The first is this general thing, and I hear this, I can't tell you how many times, no good deed goes unpunished. And really what I want to focus on with this is the accidental client situation. And I want to think about family, members of the church, for instance, or other organization you might be involved in, extended family friends, corporate constituents, beneficiaries, even prospective clients, and sometimes unrepresented parties that we are dealing with. When the accidental client situation comes up, what you hear attorneys say is, I never intended to create an attorney-client relationship. And my response is, I appreciate that. And I know that's why we call it the unintended creation of an attorney-client relationship, because it's not about you. They'll also start to say, you know, there's no fee agreement, no money exchanged, on and on and on. And I keep saying, it's not about you. The accidental client is sort of this reasonable person standard, regardless of the circumstances, dealing with corporate constituents, talking to a family member or an extended family member, Uncle Joe, you know, those kinds of things. If it's reasonable that as a result of the exchange, I'm this person, and I'm responding to the email, the phone call, the conversation at the courthouse steps or in the backyard or at a party, as if I am receiving some advice from a lawyer, and it's reasonable, foreseeable that I will act or rely on this advice in some fashion, you got a problem if your advice isn't correct. So I just want to throw out there, be very, very careful about casual conversations. We literally have had the cocktail party claim and others just like it. So caution. When that JD's after your name, these casual conversations can create problems.
Jessica needs to be here for that.
This is a big one, and we're going to explore it a little bit. But I just want to underscore, poorly documenting your files really is playing with fire. We see this in all kinds of situations in terms of word against word disputes, be it attorney discipline arena or the malpractice arena. If you end up in a word against word dispute, start to assume you're going to lose. The burden is on you to document. So what are some of the key things we want to focus on? I want to really focus on documenting scope. And first off, encourage you to stop with the excuses, and don't start with them because you're very early in what's coming here, which is exciting. But a lawyer say, if I have to throw a 5-page contract out every time a new piece of business comes in from a current client, they're going to be offended. Okay, I agree with that. It doesn't mean you don't have to document scope. And there's all kinds of other, it's not worth the time and the effort, and on and on and on. All I can say is, even a confirming email right to your audience. Good to see you today, Alan. Of course, I'll be happy to help you with this contract issue at the dealership. Regular rates apply. Please let me know if there's anything I can do. Say hello to your lovely wife. I'll see you next week at Rotary. Something like that can be very appropriate. But it's what we're trying to do here is prevent running with assumptions. It's about getting to role clarity. Okay, you need, even with sophisticated corporate clients, there have been situations where I thought I told you that. I left that in the voicemail, or I said this in the email. Did you read all the way through, or whatever it might be? We need to make sure that there's no assumption about who's doing what. Again, doesn't need to be a 5, 6, 10-page contract every time. Confirming email, letter of clarification, those kinds of things. And it really is an essential piece of documentation, because think about if a claim comes up. What's the first thing when a file comes to a carrier? What are we looking for? We're looking for scope of representation, because that starts to put some parameters around exposure. You know, you may be saying, I was retained just to do A, but the client is saying B and C on top of it. Absent a writing, we're in a word against word dispute already. We're going to have to reserve higher than we otherwise would. It's going to take more time and money to defend. So it's essential that we have something here. And it's extremely important if you ever move into limited scope representation. You really have an affirmative obligation now to document not only what you are going to do, but what you are not going to do. Extremely important and mandated by the rules in many jurisdictions. So if you're going to limit your scope, it's in writing, period, okay? We also need to think about documenting that it has concluded. Many attorneys say, I don't want to do that because I don't want to say goodbye, get out of here. You know, a letter of closure is not a goodbye, get out of here letter. It can be, I swear, I have seen so many incredible situations. One of the most effective marketing tools you will ever have the opportunity to use. And it's simply, you know, this thank you. Somebody really honored you by turning over and entrusting to your competent hands, you know, their legal issue. That's a big deal. Honor them back and say thank you. This concludes my representation of you. It has indeed been a pleasure. I hope you find or have found my work to be exemplary. Look forward to working with you in future if and when the need arises. I'll see you next week on the Jones matter if there are other things open. You know, so it isn't a goodbye, get out of here. But it can cut off just some other benefits of this. It can cut off unintended reliances. You know, think about people that come in, you know, flat fee in and out work, simple wills, corporate, you know, small business formations, that kind of thing. And lawyers are saying, well, this is just flat fee in and out. I don't care what you think. What does the client think? I have found my family lawyer. We have found our corporate lawyer. And they may have some expectations. If you're not prepared to meet that, send a letter out. Here are your wills. They should be reviewed every 3 to 5 years. Here are your corporate books. These are the formalities you need to follow. You've not retained us to help you with that. Good luck. It's been a pleasure, you know. It can document final instructions. That's kind of getting to here are the corporate formalities you need to follow, et cetera. It can come up in a variety of situations. Lawyers are often good about talking about, you know, don't forget you need to do this, you need to do that. And now that I'm done, could be as simple as you need to go file the tax returns and, you know, pay the bill and here's the deadline. But if they didn't hear it clearly, didn't understand or don't follow through and there's some fallout, they can and at times will sue you. And we don't have written documentation that they've been informed as to what they need to do. These letters can be important for conflict resolution, and very briefly, the issue that arises is when is a client a past client? You know, if we're looking at a conflict situation, are we in 1.7 current client rule or 1.9 past client rule? And a lot of lawyers say, well, time must matter. Or we have a bright line, you know, it's been 6 months, or the deed's delivered, the contract signed, the judge signed a final order. So they're looking at time or these bright lines as being determinative on the issue, and it isn't. There's nothing in any jurisdiction in the rules that talks about that as being relevant. When you look at juries and you look at cases that this is an issue with, it really boils down, have you documented? Is there a letter of closure? Once you have a letter of closure, you have a past client. If you don't have a letter of closure, you have an inactive current client for conflict resolution purposes. It's one of the reasons why closure letters are kept as a part of the database in really good firms that have, if you will, state-of-the-art conflict systems. Another thing to keep in mind, you know, when does the statute of limitations on malpractice start ticking? When does that clock start ticking? In a lot of jurisdictions, when a closure letter goes out and we've documented that the relationship has ended, something to think about. And as I've shared, these things don't need to be formal. Here are several traps that I really, really want to underscore for you. So many things are written about and ethics opinions on and CLEs and whatnot on what we have to do as a lawyer when we are intentionally choosing to limit scope of representation. But far more frequently, it's the client that's placing limitations on our scope. That happens all the time. I don't want to pay for the appraisal. I don't want to pay for all that electronic discovery. That's got to be expensive. I want to rely on this research or what somebody else has already prepared. These kinds of things. So at times it's even just trying to save a little green. Well, what happens if there is some legal fallout by their being cheap, for lack of, running with the current kind of example here? They're going to sue you. And if we don't have a writing that talks about, I advised you to do this, and you made a decision based on cost not to, and I have shared the legal ramifications about what might happen if we sort of do some discount stuff here. And I have no problem doing discount stuff, okay? I get the reality. People only have so much money. And at times, spending a lot of money on discovery isn't worth it. But we need to let them know so that they can make informed decisions. I would even argue ethically, it's mandated under 1.4 communication. How do we allow them to meaningfully participate in the decision-making process? It's their case, I take it up even one step higher. If a client refuses to follow your advice, we've had some nice losses on this one. Here we need to say, I am advising you to do this because, and document why the client is not wanting to do, what is the reasons? Because they're going to say, I didn't say that, I didn't know that. We really need to be very, very thorough in our documentation of the advice given and the decision-making process. And the cover track simply refers to extended family members, long-term friends, these kinds of things, people that we are very, very comfortable with in terms of personal relationships. Lawyers don't want to be offensive. I did wills for my parents a number of years ago. I didn't have a formal contract with them, but I assure you, I had a written record, again, of the advice given in the decision-making process. I wasn't really concerned about mom and dad. I was concerned about other family members once they die. And so I don't want to be challenged on things, okay? So sometimes when we're doing work with people, it's tempting to say, well, again, based on the personal relationship here, these people will never sue me. I got to tell you, that's way off. That's very much incorrect. They really will. And the reason is because how they look at the relationship based on the personal relationship they have with you, they can't ever imagine you allowing them to have any harm, so they'll actually say things like, would you bring the case against yourself and help bring the claim against yourself so we can recover? I know you have a policy out there, it's more than enough to handle all this. They expect you to be loyal, and that comes with the friendship. So we kind of look at this in two different ways. So again, just something to be a little bit aware of. Think alternative documentation with people that you feel really close to and good about. Okay, could even be staff or family members of staff. We're doing some quote unquote legal favors now and again. It's real work. Okay, document your way through it. Okay, here very quickly are this fee suit stuff. Why did carriers say don't sue for fees? Well, I can tell you that good attorneys that got good outcomes, great results, these kinds of things, have been sued for malpractice, and we've had losses that have been significant because the malpractice arena is a different world. It's sort of like med mal. It's perfect or we got problems, okay? And you don't want to put your work unnecessarily, needlessly under that lens. And when you sue for fees, the risk of a malpractice counterclaim is far higher in terms of just a malpractice claim coming. So these are some general things to think about, and I'll share a thought about all this here in a minute. But, first off, don't accept clients who can't afford your services. Why put on the victim here shirt? Okay. Have written fee agreements, bill monthly, detailed billing so people understand and know what does all this mean. Keep current with daily time entries. That's just going to help you with your income. Review all bills to make sure there aren't mistakes. Copy the client on work products so they know what's happening and, again, not surprised by this high bill. Take prompt action on delinquencies. If you sit and wait and wait and wait and wait 6, 12 months out before you start to do this, think about it. You're giving them permission not to pay you. If you don't pay the car payment or the phone bill, you understand bad things are going to happen relatively quickly. Somebody's going to get after you and you might lose your car, or they may turn off the heat, or they may, but nothing happens if you don't pay your lawyer bill. So often, so again, it's take prompt action on delinquency, bill monthly, and follow up. You might collect retainers, call the client, find out, why aren't they paying, this kind of thing early on, so you can make some decisions. But here's sort of my bottom line on all this. Because I actually, I have to deal with the real world, and I'm going to tell you there are a lot of lawyers out there, particularly in the economy we've had in recent years, that have and will continue to sue. And I personally, I understand the desire, if you will, to hold people accountable. The biggest mistake that is made, and it kind of gets back to the very first thing we talked about, who, don't bring on somebody who can't afford the service. They say, I did a good job, I got a good result, I deserve to be paid, and these kinds of things, and so they sue for fees. It's irrelevant. Take that off the table. I mean, I would hope that would be the case with all the work you're doing. The first of a series of questions you must always ask, is there money out there to get? If the answer to that is truly no, you're done, walk away. I've had conversations where people have said to me, well, Mark, it's $5,000. I said, look, the headache and the lost income and all the stuff of just dealing with this, it's not worth it. Walk away. I've had others say to me, I'm not walking away, Mark, it's $100,000. And my response is, look, if you are foolish enough to allow somebody to get into the hole to you for $100,000 when they can't afford the first 1,000, you need to rethink your business model, because you're not going to survive. It's just that simple. We need to learn how to have conversations up front. How do I determine if you can afford my services, that kind of stuff? Okay.
I have a question.
Yes.
So, if, for example, what type of liabilities an attorney will have if they really stop working because a client is not paying? Like
work stoppages, if you will, are completely prohibited under our ethical rules. You cannot do it. Okay? Period. So is there liability to stop working until I get paid? You bet. And it's your law license. Okay? That's the liability. Can't do it. Comes with the territory.
We're stuck.
Yeah, kind of crazy. It's a different world. Law is a special little place. Any other question on that?
that's a
All
good
right.
answer.
Let's talk a little bit about calendaring concerns, because again, I want to see you guys not develop bad habits. Okay, this is the most frequent source of claims, calendaring problems. Some of the things are, in firms of any size, no firm-wide master calendar. We are our partners' keepers, and we need to know what everyone else in the firm is doing or not doing. If I have a depression that's chronic and long-term and severe, and I just stop making decisions, doing anything, you guys want to know about that as soon as you can to help me, and more importantly, protect your clients, the firm's clients. I'm aware of a situation a number of years ago where this is the very situation that was going on. No one was aware of each other's calendar, and a depressed attorney stopped working. It was hiding files on the trunk of his car, behind furniture, under carpets, not kidding you, but still acting somewhat normal day to day. We had 22 claims out of that situation. And the other lawyers fired the guy and said, Alps, why are you penalizing us? We weren't depressed. It wasn't our problem. Excuse me, you are a firm. and our ethical rules say so. We are our partner's keepers. 5.1. Okay. Master calendars can help with just kind of keep an eye on everybody. We know what's going on. Or even somebody's sick and doesn't show up. Hey, do we have, does Bassingthwaite have a hearing this morning? We need to make sure that's covered if he does. Oh my gosh, he does. Somebody get over there right now. And I'm too sick to even think and get out of bed. And, again, this has happened. We've had a claim out of that very scenario. No true redundancies or backups. Again, think about flyers, floods, ransomware, all kinds of tech things. If the main calendar is lost or destroyed, what's the backup? So we need to make sure we have backups. But I want to focus on redundancies. This is a key idea that we need to understand. A lot of lawyers think that carriers are looking at redundant systems. We really aren't. What we're looking for, and what we even give premium credit for, is independent redundancies. So let me describe, give you an example of what I'm talking about. I'm going to make this very simple. I'm a lawyer, and I have one staff person. We've been together for a number of years, and here's what happens. My paralegal gets the mail and does all these things, but basically is entering everything into a desktop calendar, daytimers or something. And then I do some plaintiff work. So they go over to the file room and put all the critical deadlines in a card system. Then this individual sits down at my desk and enters everything into Clio, and it's backed up to my Droid phone. And so I think Apple's going to love me because we have 4 calendars. No, we don't. We have 1. It's that initial calendar that my staff person is maintaining, because all that person is doing is taking that calendar around all the other sources and copying the information. What if he or she makes a mistake or fails to glean, enters something incorrectly, or fails to glean a deadline off a document so it never gets entered? We got a problem, okay? We have 1 calendar and that's it. Now, independent redundancy, we could have a single entry cross-check. Now what that means is my staff person does everything just as I have described, but independent of that person's efforts and solely for the critical deadlines that I am concerned about, I will look at the original document, the original source. And so I might sit down at my desk, open up Clio, and verify, did he or she get every date off these documents, and were they entered correctly? It's a second set of eyes. Now we have single entry cross-check. It is a risk management process to assure the accuracy of our calendaring process. Double entry cross-check. Now again, this is very simple in terms of a one attorney firm. There are all kinds of ways that this can play out, literally hundreds in firms of even 2 or 3 lawyers and on up. But double entry cross-check is my staff person does everything in paper. And then independent of her or his efforts, these original documents come to me, and I build and maintain Clio separately. So I'm entering everything into Clio. Staff person is entering everything into the daytimers, and a backup is the card file on the paper side, and my phone on the digital side, if you will. So that's the double entry. The cross-check once a week, month, quarter, whatever our practice needs dictate, we will get together and do calendar review. And we'll just look out the next 6 months, 12 months, whatever it might be. Hey, I have a deadline here of June 15th. You have July 15th. Who's right? Because if it's June and we're relying on July, we could blow a deadline. So this. Think independent redundancies, and it's all about designing a process that seeks to, by its very design, its very nature, that seeks to identify a miscalendared item, a data entry error, whether it's not gleaning it again or entering it incorrectly, okay? No accountability or quality control. It's just, addressing who's putting what entries in, So it's about trying to have a trail. There's a mistake here. Let's figure out, could be initialing documents so that we know who saw what and those kinds of things. No system standardization really is dealing with, let's say that, again, The four of us are a firm, and each of us do our own thing. Okay. One might be just a daytimer's pocket calendar. One might have an iPhone, and we were just all doing something different. That creates potentially very significant problems. If there's an impairment, a sickness, how do I know what's going on? We all need to do the same kind of thing. If for no other reason, again, staff. Well, Bassingthwaighte does one way, Alan does something else, and they're not used to us. And so a little coverage time on a vacation of my staff person, and mistakes are made. Standardization is another just significant risk control tool. I also like readily accessible calendars on a 24/7 basis. That's to get, again, I forget to take my calendar home with me and over the weekend and Sunday night, daughter says, Dad, I have a dentist appointment in the morning. Mom's calendar's too busy. Can you take me? Can we, pull at the heartstrings? Can we go early and stop at Starbucks or something? Sure, sweetheart. I don't remember anything on my calendar. But had I had it with me and looked, there's a 9 o'clock hearing. And as a result of my missing that, there's a default judgment. I'm not making this up, as you can guess here. So this is another example of the value of having calendars available 24/7. And again, the data says be very, very concerned. And the data is roughly, 25, sometimes 30% of claims across the United States in any given year. And it kind of oscillates a bit in this range, are due to calendaring missteps of one sort or another. So again, a very significant issue. And I want to briefly talk about the reconciliation process and again, try to avoid the development of bad habits. Theft of client funds is rampant, absolutely rampant. Too many lawyers, from solos to even larger firms, view this as a back office function. Read your rules, the ethics rules. It's not. You're responsible for it. Somebody steals money from you in terms of an office manager, guess whose license gets pulled? Yours. Okay? So one of the things I just want to focus on, the bank statement. This is just very basic, but something to think about. Any firm should have an attorney review the bank statement every month. It should come to the reviewing attorney unopened, no exceptions. Staff person sends it to me 2 or 3 months in a row with it opened, I'm firing that person. They'll get a warning once, second time out. I do not mess around with this. And it allows the attorney to just look and understand what's going on. I'm going to make sure that there are no forgeries on the checks that are returned. Or you can look at this online, depending on what the bank does. I'm going to make sure I understand that every check there, I have the corresponding debit in the account. I want to understand all the electronic debits and just make sure that there's nothing funky going on. Okay, if you allow the bank statement to go to someone else initially, trust me, there are all kinds of ways they can start to run a double set of books and things get crazy. And also, remember, we need to do a double reconciliation. And really, and I'm talking about the trust account here now, we need to do a reconciliation of the bank statement to the general ledger as well as the individual sub-accounts. That's what a double reconciliation is. In other words, and all of these reconciliations must be balanced to the penny. In other words, if I have 2 clients named Smith, I want to make sure that the check that was written or the deposit that was made on behalf of Smith was the right Smith. Okay, so I may give the bank statement to now the bookkeeper, whoever does this, and he or she will do her magic. But then this bank statement comes back with the original, with the reconciliation report, which is a double reconciliation, and I do a review of the numbers and I'm going to sign a date, just again documenting attorney oversight. I am responsible as a lawyer for client funds. And I am darn well going to make sure I understand what's happening. You cannot just completely hand this off and then say, I didn't know somebody could steal. Lawyers have lost their license trying that one. Okay, so we really need to stay on top of it. There's some other things I'm not going to get in too far. Just seeing if there's a time. I want to allow a little time to talk about cyber too. Um, I can simply share if you're doing like QuickBooks or other online accounting systems and things, you can set up audit trails and audit functions. Don't disable that. Get the reports, review them, look. Checkbooks, you should have 2 signatures on high amounts anyway. Checkbooks should be locked up. And undeposited checks, we need to log them in or record their presence in some fashion pretty much upon receipt and restrictively endorse as early as possible. And again, lock them up if they're going to stay on site any length of time. I'm going to skip this in the interest of time, other than to say that honestly, I can't tell you how often that it's a long-term trusted employee, and I include in the definition of employee here in terms of people at a firm, attorneys themselves are so far often the problem. Bad guys don't announce their intentions. So we really just need to be wary of altered behaviors and whatnot, and have systems in place. Our rules mandate this, that seek to catch and or prevent theft of client property. So that's real quick, that one.